we are ready to do this one. National Content Review. Again, on page 3, you need a 70% to pass, which means you need a score of 56, and you've got 2 hours to complete this exam. Do I think you'll maybe need the whole 2 hours? No, but if you're doing it too quickly, I'm worried that maybe you didn't slow down and read questions. So just be very, very, very careful. Property ownership. Let's get into page 4. This gives you kind of the definition of different types of real estate. But let's just start with land. Land is going to have air rights, surface rights, and subsurface rights. Let's start with surface rights on page 4. I think your challenge of that is going to be knowing about water rights. So riparian rights or littoral rights, I don't know whether you need to know those names specifically, but here's the concept. If you've got a beachfront property along the Atlantic Ocean, your property line is going to stop at the high tide or the high water mark. If you've got a major water source that is government controlled, like the mighty Mississippi, you're going to own to the banks of that river. If you and I are neighbors and we've got a little stream or water source between us, then we are probably going to own that property to the middle of the water source, but we can float all over the water. I just can't fish from your side or build a dock. But obviously it would be impossible to float my boat just on my side of the lot line on water that's a little uncontrollable sometimes. So you can float, but we just wouldn't fish or build a dock on your side. Okay. I think a really good opportunity though for you is at the top of page 5. That's going to be doctrine of prior appropriation. That means that in order to irrigate your crops, in some areas where water sources are scarce or limited, you've got to get permission from the government to irrigate those crops. You've got to get permission. Then the next bit opportunity for questions is going to be on page 6. This is where we talk about land plus the permanent structures that are attached to it. A house, a building, right? All the things. When we do that, now we need to talk about personal property versus fixtures. Personal property is your stuff. But when it's permanently attached to the real estate with the intention of staying with the real estate, it now becomes a fixture and it gets sold with the real estate. So we're talking lighting, carpet, cabinets, mirrors in the bathroom. Those things that are plumbed in, framed in, electrically wired in. Those are your big rocks if it's going to stay or if it's going to go. Now, for the exam, we've got a challenge to understand the difference between what stays and what goes. And as complicated as we've been preparing for the exam, my real test for you is going to be if you turn that upside down, that house upside down, for example, and shake it and it falls, it's going to be personal property for this situation. I know that when you start practicing real estate, it may not be that simple. There's a lot of different layers to it, but at the same time, for this test, I think that will help you answer and guide through. Does it stay or does it go? Going being personal property, staying meaning it's a fixture. It's now a part of the real estate. Keep in mind, mobile and motor homes are personal property. So you buy a piece of land and you park your mobile home on it. Good for you. I mean, that's not that you don't have a place to live. You own real estate. That's the land. But it does not include that mobile home. That is personal property because it's not permanently attached to the land. I then would go over and learn about plants. I would know the difference between an annual and a perennial. An annual is personal property. You've got to replant it every year. Our good example for that in Iowa is going to be crops. A perennial regrows itself every year, year after year after year. Trees, shrubs, bushes, grasses, your hostas. So crops are personal property. Perennial is real estate. It's a fixture, it stays. The other big one for the exam is going to be a trade fixture. So it's a trade fixture. Now, I know it has the word fixture in it. I did not come up with any of these names. But a trade fixture, remember, is personal property. It is something that a tenant would use for the course of their lease in a commercial setting. So it's got nothing to do with residential properties. If you have a test question that's talking about trade fixtures in someone's residential property, that should be a red flag, I guess I'll call it, because those two things don't go together. A trade fixture is for the course of doing business. It's things that a tenant are going to put into a property for them to do business. The example I gave you is that hydraulic chair that your beauty operator uses when they cut your hairs, right? You want that secured to the ground so that you don't fall over. But we also want to adjust it so that your beauty operator does not get carpal tunnel. So they're going to permanently attach that and then be able to remove it at the end of their lease. That's a trade fixture. The other two that I would like to hit on page 8 is a homestead, and then let's maybe hit dower rights, just to be careful. Homestead. This means that your personal property that you live in, they might refer that to as your family home. That is protected against most creditors. So homestead protects your personal home that you live in, your family home, against most creditors. And the reason it says most creditors is because if you've used a mortgage to buy that property and you stop paying the mortgage, now you're in foreclosure, right? Because you use that house purposely as collateral. Dower rights. This is the idea that it takes one person in a marriage to buy a property, but it takes both of them to sell it. Only one person can even be on the mortgage. Maybe only one of them even qualifies for the mortgage. But because they're married, they've got dower rights. So that automatically gives the married spouse interest in that property. That one may not come up on the exam, but it will come up in your career. The bottom of page 8, severalty. I know this has the word several in it, but I want you to keep in mind this is severed from everyone else. You're the only person that owns that property. Under co-ownership, absolutely get in that joint tenancy. That could be 2 or more owners, married or unmarried. What is distinguishing about it is the right of survivorship. That means if one person dies, there's just one less owner. It also avoids probate. Remember, probate is that judicial process of validating someone's estate, whether they've got a will or not. It avoids that. Those are 2 really key things to know about joint tenancy. Tenancy in common, or tenants in common, that's where you're going to own your fractional interest in it. And then I did mention in tenancy by the entirety under married couples. This does, if you've got no other option about joint tenants, this one does have an element of right of survivorship, but only because back in the day, my understanding is when they used this, they considered a married couple to be one person. 2 hearts become one. Light your unity candle. Read the 1 Corinthians, whatever that is that they do at a lot of weddings. It's that. Trusts might be helpful for you to review. That this is when we have someone put personal or real property into this entity of a trust. Someone manages it, called a trustee, and it's for the benefit of a third party. They're obviously called the beneficiary. Page 10, condominium. This of the 3 is the one I think you really need to know. It's where you own your unit plus shared spaces like green spaces, parking lots, elevators, maybe a workout room, hallways. You own that in common with the other owners in the homeowners association. But the key with a condo is that you actually have a deed to your unit, an actual deed. That could be a good one as well. Page 11, we've got a lot about encumbrances. These are things that run with the land, such as easements, encroachments, deed restrictions, and liens. I think you've got a lot of opportunity for questions out of this. An easement is going to be the right to use someone else's land. But again, it does not rise to the level of control or ownership. Your most common type might be a neighbor that allows you to use their driveway to access your property. Now, what's key with these easements, why they're encumbrances, and we use the terms run with the land, is because every time that property is bought or sold, that easement stays in place. It doesn't have to be renegotiated when I sell or buy. It runs with the land. It stays as part of the title work in the abstract. Haley mentioned she saw her mom's stinky abstract this morning. It smells like antique, doesn't it? Yeah, a lot of them are old. that stays. The only way an easement, for the most part, is going to go away, for the most part, is either it's abandoned for probably 20 to 30 years or more, or another option would be if one owner bought out the other owner. Now they own both lots, so it's unnecessary. An encroachment is when you've got personal property creeping on over to someone else's lot, or maybe it's even a fixture that was put on the wrong side of the lot line. The most common one is a fence. That's the idea of an encroachment. Deed restrictions should be one for you on the exam. And I think that you need to know what it is, and I think you need to know how it functions differently than building codes. Deed restrictions are going to be created by a developer or a homeowners association. It's going to be covenants that describe the use of the property or the style of the property. It is going to be managed either by the developer or the homeowners association. Building codes are only for safety, and those are going to be managed by your local authority, most common your city that you live in. Liens is a big one. And I've got this nice and organized for you at the bottom of page 12, top of page 13. Again, a lien is a charge against a property to secure that you'll repay a debt. The most common type of lien is a mortgage. It is voluntary to the voluntary action on your part to get a loan. You chose to do that. And it is specific to the property. It's not just a line of credit like your MasterCard that goes with you everywhere that you do. No, it is a lien only for that address, nothing else. I would review that and know that that is a specific voluntary lien. I've got those all labeled out for you. Then if you flip the page, I would want you to know that not all liens are encumbrances. Non-encumbrance liens means they're general liens. That's just you living your life. That you've got some sort of, the big one is a judgment against you, where you've gone to court and a judge has determined you owe money to someone. Child support is the one that we've talked about the most. And in my opinion, it's going to be the most common that you might find in real estate. It does not rise to the level of an encumbrance because it's a general lien. Then we got into descriptions of land. The first thing I want you to know is that legal description needs to be in its entirety. If you need more room, get an addendum. Add it to the contract. I would know that meets and bounds. I'm now in the middle of page 13. This is the first type of legal description or survey that was used to create a legal description. This is where we use that point of beginning or a monument to start it. It's also that one where you might get asked if you go 100 feet north, 85 feet east, 100 feet south, how do you get back to the point of beginning? You got to go 85 feet west, correct? The rectangular government survey system. This is where we're creating those townships. Every 6 miles going north, every 6 miles going south. Where those lines intersect creates a township. The lines that go east and west are tiers. Draw that arrow on the top of the T. Those lines that go north and south, those are ranges. Draw that arrow on the side of the R. Both of those are township lines. Just specifically east and west is a tier, north and south is a range. Now, in that township, there are 1 square miles called sections. Great. Even deeper, I think you need to know that 1 acre is 43,560 square feet. Call me. 43,560. And you might be asked a question where you need to convert square feet to acres. So you would take the square feet divided by 43,560, and that will give you your acres. And then lot and block, that's going to be a recorded plat map. Wow, 8 test questions out of that section. Land use controls. You got 4 in this one. And it talks a lot about police power. These are the laws put into place by your state, county, and local government to keep you safe. Building codes, zoning ordinances, occupancy limits. Now, we've already talked about building code versus deed restriction. So where I'd like to focus for you, page 16 at the top, is non-conforming use and a variance. Non-conforming use says that if building codes change, you're grandfathered in. The city won't require you to spend money updating your property to meet their new random code. You're grandfathered in. But if that property is demolished for any reason, wind, fire, destruction, you've now got to rebuild it according to the current code. If for some reason it would be impossible to rebuild it back, or to build it now to the current code, it would be impossible, then you would need to get permission from your local government to build it differently. And that's called a variance. A variance. Now we've got a question in the chat about zoning. For example, we've got residential, commercial, industrial, agriculture, special purpose, multi-purpose. My best answer for you is, what does R1 mean? And if you go on the county assessor's page, you'll probably see something like that. R stands for residential. Then my understanding is the number after it is an idea of the density of that property. So an R1 is going to be single family homes, where an R4 might be a 50 unit apartment complex, right? You've got a lot more people living in an area than a single family property. Does that make sense? So I would look at the number after it. That's what I would consider a density factor. Eminent domain. Oh, if you do not have an eminent domain question, Alex, I'm going to be so disappointed. What we've got here is we've got to have just a quick verification that it is a government right to acquire private property for public use. So the government cannot acquire private property for me to build a house on. It's got to be for public use. They've got to prove that they're offering a fair price. And if someone does not want to comply, the government does have the right to take them to court, and that's what they call condemnation. So I would know that definition. That's a good one for you. I'm certain that you're familiar with property taxes. Special assessments is a property tax for a special project that that property owner is going to benefit from. Your city comes in and decides to put in sidewalks, and your property is going to benefit from it on that street. They're probably going to find the money to fund that project by charging a special assessment just to the homeowners that benefited from it. So it's a special tax. And then the other big one maybe to know is an exchange on page 17. A way to divert from paying capital gains taxes. There is a capital gains tax anytime that you would have a net profit, net after expenses. There can be capital gains taxes. A way to divert those is to put that money, that net profit, into a 1031 tax exchange. It's an IRS code, and as long as you buy similar property within a certain period of time, you can avoid that tax. Valuation and market analysis. Page 18, you've got 6 test questions up in here. The first thing I would know is the definition of an appraisal. It's an opinion of market value, market value, market value. How many times do you think I've said market value in the last 8 days? 17,000? I don't know, close. Broker price opinion. I would know who could do this. It could be a licensed appraiser or a licensed agent. It's a short form version of an appraisal, often used to remove private mortgage insurance, for example. I would know the 4 elements of value. That is demand, utility, scarcity, and transferability. The acronym, I do have an acronym for you on that one. You guys like acronyms. Of DUST. D-U-S-T. D-U-S-T. Demand, utility, scarcity, transferability. On page 19 in the middle, I would know that the first step in the appraisal process is to define the problem. Why are we doing this appraisal? Is it a purchase? Is it a refinance? Are we removing PMI? Are we doing a cash out? Are we doing a home equity loan? And then the steps for a uniform appraisal report. I do think that you could have a question about answering what would make the best comparable for an appraiser. I would rule out foreclosures because it's a distressed property. I would rule out a transfer between family members because that's not a normal transaction, right? There's usually something happening there for estate planning that's not going to show its real, true market value. What you do want to look for is properties in the same neighborhood within the last 12 months. That's what they're going to use for their comparable properties when they're doing an appraisal on the subject home. Under principles of value, page 20, there's a lot of these, right? There's a lot of terms here. Anticipation is a big one. That's the concept that an event happening or not happening could affect the value of properties. For example, Amazon Fulfillment Center is announced it's coming to Bondurant. Right? That excitement is probably going to change values, right? We used Maytag closing in Newton several years ago. What do you think that did to values? Right? Having an employer leave, major employer leave. Now, here's what I would know for the exam. If a seller calls you and says, Kim, come list my property. I've heard the local manufacturing plant is closing. What are you going to do? You're going to list it right now. If they ask you when's the best time, it's now. Now, before those rumors perpetuate, right? Change is basic wear and tear. No property ever stays the same forever, right? We've got storms, wind. Conformity is how well does it fit in with the rest of the neighborhood? Or is it super, super unique? Highest and best value just simply means, is this property being used for its best use? That would give it its highest value. And then we'll talk about substitution here in a minute on page 21. As we get into these three types of approaches to establish value. That's on page 22. We've got the sales comparison approach, the cost approach, and the income approach on the next page. The sales comparison approach is the most common, and it's used when we've got a lot of really good data like residential to pull comparable properties and substitute their elements so that it looks most like the subject property that you're looking to price. When you make the price corrections, you always do it to the comparable properties, not the subject that you're pricing. And you're going to move those substitution amounts because we're trying to get it to look most like your subject property. So if a 3-bedroom home sells for $180, and we know a 3rd bedroom is worth $3,000 and a fireplace is worth $2,000, how much is a 2-bedroom with a fireplace? What's its most likely sales price? Well, we're going to take the 180 that sold and we're going to make it look like a 2-bedroom. Subtract 5,000. Then we're going to make it look like it's got a fireplace. Add 2,000. That makes our most likely sales price $177, for example. Cost approach is going to be really unique real estate, most likely commercial. It's the concept that we're going to take it back down to bare land. We're going to build it brand new, and then we're going to depreciate it to its actual value. Depreciate means bring the price down. Appreciate means bring the price up. There are 3 factors with this depreciation in the middle of page 23. Physical deterioration, functional obsolescence, and external obsolescence. Physical deterioration is curable. We can fix it. It's basic wear and tear. Functional obsolescence is incurable. And it's something that is outdated structurally, or maybe even electrical or plumbing, but a very costly repair. It may not be able to be fixed. And external, or I've also seen it called economic obsolescence. That's going to be something off of your property that affects your value. Maybe the retina burning orange painted house across the street. It's overgrown with trees, 27 cats, not on your property, but very well will affect your value. The income approach uses rent, future rent, combined with a capitalization rate or rate of return to establish its value. Again, great, obviously, for rentals. Now we're on to financing. 8 questions on this one. Page 26, we've been using the term mortgage quite a bit. That's a specific type of loan used to buy real estate. And then I've got some terms in here that are going to become math on page 27 and 28. So let's pop ahead to page 29. Absolutely no acceleration and alienation clauses. Acceleration means if you start to default on your loan, they reserve the right to move up the due date of when you need it paid off. You can't just take all 30 years to get back on track. Alienation clause means if you abandon the property for any reason, you sell it, you will it after you die, or you gift it, you've got to pay off the balance. That was page 29. Page 30 is discount point. I think that's a good one for the exam. However, there's math on it, but I'm going to give you the definition here. Discount point is 1% of the amount borrowed. 1% of the amount borrowed. Foreclosure there in the middle. That is my concept of you buy a house with a loan from a bank called a mortgage, and you no pay, you no stay. They're going to accelerate the due date. If you can't pay off the balance, they're going to go into foreclosure. Once it's foreclosed, now past tense, the bank owns the property, and a bank-owned property is also known as an REO, real estate owned. Loan origination fee on that same page. This is a fee a borrower pays just to get a brand new loan, not to refinance it, not when it's assigned to another bank, but just for creating the new loan. Page 31 at the top, towards the top, is a short sale. A short sale is when we're selling it short of what we owe as a balance to the bank. It's not short on time. It's short of what you owe. Now, what they forgive, let's say you owe a balance to your lender for that mortgage for $150,000. But the house now is only worth $120,000. That $30,000 that they forgave or they let you sell it short, you might get a question on if you're 1099'd for tax purposes on that. And the answer is no. There's a law in place with mortgage relief, so it does not require a 1099. Page 31, types of loans. An amortized loan is fully amortized loan. Is a loan where the principal and interest payment are the same every single payment. So if you've got a 30-year mortgage, this sounds terrible to say out loud. That is 360 payments, y'all. Am I doing the right math? I don't like saying that number out loud. With that being said, all those payments are going to be the exact same principal and interest. Now, the amount that goes to interest and the amount that goes to principal, that may change over time. You might be paying more to interest in the beginning and less in principal, but the more you pay it down, the more you're paying towards principal and less in interest. So it might change, but the total of it remains the same the entire time. Three major ones I would review: conventional loan, FHA, and VA loans. These are all fully amortized loans. Remember, conventional has private mortgage insurance if you're going to put less than 20% down. Private mortgage insurance, I would know, what is it for? Who pays it? Who does it benefit? The borrower pays it, or the buyer pays it, but it benefits the bank in case they default on the loan and quit making payments. Anytime you put less than 20% down. FHA insured loans, again, you get this loan with a bank, but that mortgage insurance is backed by the government. This is great for moderate to income families, more forgiving on credit score, debt to income ratios, as little as 3.5% down. The key with this one, though, is their version of mortgage insurance never goes away. It's there for the life of the loan. And then a VA guaranteed loan is for our veterans. Yay to Kyle again. Hug a veteran today. This is 100% financing. It actually could even be used by a widowing spouse who lost their significant other in battle, if they're not remarried. But what I would know about this is that CRV. Veterans pay a funding fee. That's their version of closing costs. But they can do, my understanding is that CRV is an appraisal specifically just for VA loans. And there's a term that I've recently been learning called Tidewater. It was new for me. That basically is a way for the lender to call and say, if they're starting to get evidence that it's not going to appraise, they can call and let the lender know before they continue their final report. That way, we're not shocked at the end. We kind of know what's going on in the middle. But with that, they are, I believe, as long as it appraises correctly, able to also finance that funding fee, or they can pay it in cash, or a seller can, put money towards it in an offer. They can negotiate that concession with an offer. But know that that CRV, that certificate of reasonable value, relate that to a VA loan. My next big rock, and guys, remember, I'm hitting highlights. You got a whole handout here. I'm hitting highlights. Balloon payment on page 32. That's partially amortized. So all the payments are going to be the same. And then the last one is going to balloon out, and you're going to owe that big balance at once. So your payments will be lower. And then that last one will, it'll be different. It's going to be a different payment than the others. Yeah, Diana, the example that I used was a 5-year balloon. That's 60 payments, 12 per year. All 59 are going to be the same. That 60th one is going to pop up in a balloon, and you're going to owe the big balance. You've got other financing techniques on page 33 to review. I would know that reverse mortgage at the bottom of page 33 is for folks 62 years of age or older. Instead of making a mortgage payment to a bank every month, they're actually receiving one as a way to give them a little cash flow. So it's got reverse amortization to it because the balance is going up instead of down. The financing system on page 34. You've got the primary and the secondary mortgage market. Primary originates the loan, then they assign it or sell it, assign it to the secondary that then services the loan. That allows the primary to go out and make more mortgages, charge more loan origination fees. And I would know that the secondary mortgage market, the major player is Fannie Mae, the major player. Financing laws. I would have you review those triggering terms. And know that when properties are advertising, when banks are advertising, they cannot just say, buy this house for $500 a month. They can only do that if they clarify what you got to do to qualify for that payment. The amount down, the annual percentage rate or the interest rate. How long is the loan? What's the term of it? How many payments do you make in that length? Did you guys watch that Sears video that Ann shared on PBS? Yeah, it's amazing. Some of those payments, $26 a month. The most expensive one I think I saw was like $43 or something. But how do you get to that? Are you required to put money down? How long do you make that $43 a month payment? What's the interest rate? How do you qualify for that rate? Regulation Z is what took care of that advertising. Real Estate Settlement Procedures Act. I think Desiree asked about this yesterday. That's going to be the one where we don't allow kickbacks. There's several elements to it, but the major one is we can't take kickbacks from lenders for giving them buyer leads. Winkety wink, wink, wink. And then my other big one is TRID on page 36, the last one. Tiller RESPA integrated disclosure. This is what created the loan estimate form and the closing disclosure form. Each of those forms, the buyer has 3 days to review. And the other element is any fee on there associated with borrowing money has got to match loan estimate and closing disclosure. A lender cannot inflate prices and pass those on to the buyer on the closing disclosure. That's a big no-no. Agency. This is a big one. 10 test questions. This is in my top 3. You got to study it. And by the way, there's 6 on the state exam. And a lot of what we learned here is going to help you there. A lot. I would know an independent contractor. At the bottom of page 37. And I would know that if someone sets up a business entity for themselves, like an LLC, their broker does not change their independent contractor status. Page 38, I would know that power of attorney. We discussed this yesterday. That is a written authorization to legally represent someone on their behalf. Legal written authorization. And another way to say that is universal agent. Another way to say that is universal agent right below it. Single and dual agency at the bottom of page 38, top of page 39. Single agency is when you represent a buyer or seller, tenant or landlord. It's or. Same transaction, you represent one or the other. Dual agency is when you represent buyer and seller, tenant and landlord. You represent both in the same transaction. Dual agency by Iowa law always has to be disclosed. And dual agency, let's say that Gwen and I work for the same brokerage. Gwen has the listing and I represent the buyer. That's not dual agency. Here's also what dual agency is not. Let's say I've got a buyer that calls and says, we've outgrown our property. We just had twins. We need a bigger house. We want to sell our current one and buy a new one. That's not dual agency. That's single agency twice. The only way I would have dual agency in that is if I also brought them a buyer for their house, or if they bought something I already had listed. Does that make sense? Emily says yes. I'll take it. I'll definitely take it. Now, under fiduciary responsibilities at the bottom of page 39, top of page 40, I think you got a lot of magic here. Of the 10 test questions, I think you could have 3 or 4. I would know that when you've got a fiduciary responsibility, you're putting your principal or the person you hired, you're putting their best interests above anyone else's, especially your own. It's a special relationship based off of cold AC is the acronym I use because when I sell property, I want the air conditioning to work. Care, obedience, loyalty, disclosure, accounting, and confidentiality. I would know the definition and I would know an example. Care means the public expects you to know more than they do. Don't lie and tell them their property is worth $350 when you know it's not. You know it's only worth $275. Obedience means you follow their lawful instructions. They say don't show this house to any families with kids. We just put a new carpet. We don't want it ruined the moment we sell the property. You cannot make that promise. That's illegal. That would be a violation of fair housing. But if they say, Amy, we don't want you to advertise in the newspaper, you don't advertise the newspaper. And if you already don't advertise the newspaper, you don't advertise because it's a moot point, right? You never did it in the first place. But you follow their lawful instruction. Loyalty means you put their interests above your own. You show a hot property that you kind of want to buy yourself. You don't. You let your buyers proceed. Disclosure means we've got to keep our clients informed on facts that affect the transaction. And this could be a material adverse fact. That's a fact about a property that we disclose no matter what, because it affects value, structure, or environmental issues. Accounting means we need to be able to update our clients on the status of a transaction. Upon request is the big part. Upon request. And confidentiality means we don't share anything with the other party that would put our clients at a disadvantage. Seller representation agreements. Seller representation agreement, we've got exclusive right to sell, exclusive agency, and open listing. Exclusive right to sell means we hire one agent only. The seller cannot do a for sale by owner. Exclusive agency means they hire one agent only, but they still could do a for sale. If they find their own buyer, they can find their own buyer. Open listing means they hire multiple agents. And again, they still reserve the right to do a for sale by owner. The key with these is, when can you approach someone that you know or you have got reason to know that they've got an exclusive relationship? And the answer is, you do not approach anyone unless they approach you first. The key there is exclusive. Whether it's a buyer or a seller, you don't approach them during their period of contract unless they approach you first. If it's an open listing, you can approach them anytime because they hire multiple agents. Top of page 41, net listings, where we give the net to the seller and we just keep the difference between that net and the list price as our commission. Those are illegal. In most states, they're illegal in Iowa. We have them illegal in Iowa because those listings do not disclose the list price or the commission rate. We feel like that does not protect the public. They need to know what fees they're paying and what the list price is. Termination of seller agreements, page 42. My big ones that I want to point out are completion or performance. That's always your first opportunity. And then death or incapacitation. Again, this is for listing and buyer agreements, not purchase agreements, but listing and buyer agreements with a brokerage. Broker or seller or buyer dies, that contract automatically ends. You as a salesperson, though, that work underneath the broker, no. That contract's still going. It's got to be the broker or the seller. Automatic extension clauses, we discussed yesterday, those are illegal in Iowa. But that's where it would require the seller to give a certain number of days notice for the listing to expire. A broker protection clause. This is where the broker protects buyers that they attracted to the property during their marketing period. It protects them after the listing expires for a set amount of time, whatever's agreed to in the contract. We do this so that a seller doesn't hijack our marketing efforts and sell directly to people that we had come to the property because of our marketing dollars and efforts. Property disclosure, 5 questions. Make sure you know your role as an agent. This is page 44. At the top, those first kind of middle set of bullet points. As an agent, you need to be aware of environmental issues. Educate your clients. Look for signs. But, it's not big old but. You should not confirm or deny the presence of anything without having it be properly tested or inspected by a professional. Again, at the bottom of page 44, a residential property disclosure. This is for not for bare land, not for 5 or more units. This residential disclosure is 1 to 4 units. Bare land, 5 or more units would be excluded. We talked a ton about material adverse facts and latent defects already. Those get disclosed no matter what. Water in the basement, the well going dry. I would know the definition of a stigmatized property. This is something that's happened on the property or nearby that makes that property undesirable. Megan's Law, there in the middle of page 45. This is not a real estate law, but it is a law that requires sex offenders to register with their local authorities. I would absolutely at the top of page 46 know what is radon. It's a gas. You can't hear it, see it, taste it, feel it, think it. And then lead-based paint, I think you've got 3 options for test questions. Number 1, know that this is a federal disclosure for properties built prior to 1978, 1978, 1978. I would know when it needs to be signed prior to a buyer writing an offer or a seller accepting it. And then I would know that the buyer gets a 10-day window. If they choose, it's a 10-day window to test for lead-based paint. Now, hang on with me here a little bit because I want to get through this. But I know that we've got maybe a little break coming up, but just hang on tight with me. Let's finish up just a few more things. Let's go to page 48. I would know those 5 elements that would make a valid contract, that it's a voluntary decision, it's a set of agreements or promises, it's by legally competent parties, it's for some sort of consideration, that's the price, and that it's for a legal act. On page 49, I would know the term statute of frauds. Right in the middle of 49, this means that contracts can be oral or written. But statute of frauds says some contracts, in order to be legal, have to be in writing. They've got to be in writing. So purchase agreements and listing agreements, for example, in Iowa, are 2 of those. I would know on page 50 the term unilateral contract, and I've been relating that to the term an option sale or an option contract that we'll get to, I think, on page 57. Yeah, somewhere in there. On page 51 and the very top of page 52, of your 15 questions out of this section, this is the big mamma jamma, I think you've got lots of options here. An offer is written by a buyer or a tenant. It's given to the seller or landlord. Then there's 5 different things that can happen. Number 1, the seller can accept that offer. Acceptance includes notifying the buyer of that acceptance in writing. We also refer to that offer and acceptance as meeting of the mind. Rescind. A buyer can rescind or withdraw their offer or retract it anytime before the seller accepts it. A counteroffer is any change in the original agreement. Don't let them fool you into thinking it's just a change in price. Could be a change in earnest money deposit, could be a change in closing date. Any change is technically a counteroffer, which for your purposes on this exam means the original no longer exists. Rejection means the seller does not offer any counteroffer or feedback about the offer. They just say no. And expiration means that there was a date and time on the offer for the seller to respond, and they did not meet that deadline. So now the offer doesn't exist because it's expired. Page 52. Under this legal status of a contract, I would absolutely hit voidable. A contract written by a minor is voidable, 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 voidable. It's not automatically void. It's voidable. Voidable. And I reviewed some elements that are common in a contract. just for your career on page 53. Page 54 is where the option is. An option is a unilateral contract where the buyer is doing all the research and activities. The seller is sitting tight doing nothing, but they also cannot sell the property to anyone else. I would highlight that one. I would highlight time is of the essence. That means that things need to get done by certain deadlines within the contract. It does not mean that everything needs to be done ASAP. It means we've got to hit certain deadlines. It also means that if the buyer goes past that deadline, they forfeit their opportunity. It also means that the seller can't demand that it be done early. So for example, if we've got a 10-day window to do a home inspection and the buyer is required to list their repairs to the seller in those 10 days, on day 11, if the buyer hasn't given those requests to the seller, they've missed their opportunity and they're moving forward without those repairs being requested. It also means the seller can't call and say, do it on day 3. We need you to do it on day 3. The buyer has until 11:59 p.m. on the date of the contract to finish it. A bill of sale, I would review contingencies. This is what I call subject to obtaining a mortgage or doing an inspection. Addendums add information, amendments change it. Those could obviously be good to know. Bill of sale is for personal property. Couches, patio furniture, pianos, pool tables, that's all personal property. That goes on a bill of sale, not a real estate contract. I would know an assignment on page 56 is when we substitute a buyer. I would know a novation is when we just write a clean copy of the original. Nothing on it changes, even the dates of acceptance. We're just writing a clean copy of the original. And then I would know breach of contract. And I've got a lot of content here for you. But what I think that you need to know is if you've got a buyer agency, an exclusive buyer agency signed with a buyer, they go to an open house and buy a property with that agent, they could owe you commissions, right? Because you've got an exclusive, they would still owe you. A seller, if they sign a contract with you saying that they will pay you a commission if you bring them a $300,000 cash offer, you do that and then they say, nope, I want 310, they are in breach. They could be subject to still owing commissions as well. I could see that maybe a concept of that to get you those 15 test questions. I could see that being asked more than once. Now hold tight with me. I know it's 9:30 here, but let's just hit a couple more things. Leasing basics on page 58. That's the length of the lease. An estate for years is definite. Hard start, hard end. This is page 58. An estate from period to period is like a month-to-month lease. An estate at will is indefinite. An estate at sufferance is exactly what you think it is. Somebody needs to get out and they won't. Where I do think the 3 test questions could pop up is on page 59, how the lease is paid. A gross lease means the tenant pays rent plus their utilities. Landlord takes care of everything else. Maintenance, taxes, any association fees. A net lease is when the tenant takes care of everything. The rent, the taxes, the insurance, maintenance, any other maintenance fees like HOA dues. Typically, gross happens in residential, net happens in commercial, just so you've got some platform. Percentage lease is when we pay a percentage of our profit as our rent. This typically happens in retail. So if you've got someone that comes to you that says, I've got a booming business in Urbandale and I want to open up a location here in Altoona, how are you going to most likely charge them rent? Percentage lease. You want to take advantage of their awesome sales. Then the other thing I would know here is I would review property management, 61 and 62. I would know what is a property manager, and I would know what goes into their property management agreement. That's at the top of page 62, and we have it in our state handout as well. Transfer of title. I would know what makes a valid deed. And specifically, I would know at the top of page 64, the deed is what gets notarized. The deed is what gets notarized. Not a purchase agreement, not a lease, not a listing agreement. It's the deed. I would know 3 types of deeds: general warranty, special warranty, and quit claim on page 65. General warranty deeds are the best. Think general in the military. They're the best. This is going to warrant against title defects in the past, in the present, and in the future. Special warranty deeds typically are used with foreclosures, and they only warrant against the past and the present. They do not warrant against the future. That's why we use title insurance, so that if a flaw does pop up on title in the future, that property owner has an insurance policy to cover them. In Iowa, by the way, we only use a program called Iowa Title Guarantee, and they're part of an entity called Iowa Finance Authority. It's self-funded. Remember in the state that a broker owes interest on a quarterly basis made off of their trust account? Typically that money goes to Iowa Finance Authority and funds that. Quit claim deed on page 65. No warranty at all whatsoever. It's the worst. It's just a way to clean up title, get people on and off of title. Priority in the middle of page 66. This is what's known as first come, first serve. When a deed is recorded and then any liens are recorded on top of that, right? A charge to repay a debt. Those liens are paid whoever filed first. That's the priority. Unless it's property taxes or special assessments, those always pop to the top no matter what. And then we just talked about title insurance on page 67. I'm going to have you fast forward to page 69 with escrow accounts. This is where we hold deposits and earnest money for people so that that money is guaranteed to be made available when they need to get it back. It's not our money. It does not get commingled or converted into just my basic business account. Who can have one? A bank, an attorney, a broker, or a title company. Then let's go to prorating on page 70. 2 terms there: accrued and prepaid. Accrued is going to show up as a seller debt and a buyer credit, or debit might be the word they use. A debt to the seller, a credit to the buyer. Prepaid is going to be a debt to the buyer and a credit to the seller. Know those as definitions. And then obviously you might have some tax proration math. Now I've got one little thing I want to hit. Practice of real estate, and I know this is a big section, But let me hit this and then we'll round up. Just give me another 8 minutes. Page 74, you've got 10 test questions. I would know antitrust laws. This is one of the big sections, one of the top 3. Know the definition of an antitrust law is to prevent monopolies and to promote the free flow of goods and services. Here are some elements about antitrust laws. Price fixing. That's when competitors get together and try to lock in a price. If you're ever in a meeting with another broker that says, let's fix the price of commissions, let's just set this flat fee. Nope. You get the hell out of there. The boycott is when 2 or more businesses conspire to try to run someone out of business or create a monopoly. A tie-in agreement is when we tie 2 contracts together when they should remain separate. And the example that we have in the Iowa Code is we've got a lot for sale. A builder comes and says, I want to buy this lot and build a house on it. I, as an agent, cannot say to that builder, I refuse to sell you this lot unless you give me that listing when you build the new house. No. Now, that builder can use me for both, to buy the lot and then as the listing agent when they build it. But I cannot tie them together and make that a requirement. Those have got to be 2 separate decisions. Fair housing is the big chunk here. Fair housing is maybe going to be 5 to 6 of the 10 test questions. I would memorize who is on this list for protected classes of race, religion, national origin, sex, family status, disability. It is not your sports team. It is not your political party. It is not a felon. It is not age. It is not veteran status. It is not marriage. Under religion, page 75. Include private organization. But religious groups and private organizations can rent to their members only. However, they cannot discriminate from there. Just say female Methodists, right, at our church. And if they decide to rent it publicly, now they've got to follow all fair housing laws. Family status means you got to rent to families the same as anyone else. You cannot use kids as a way to restrict the number of occupants. That was the example of having a little old lady tenant that says, don't rent to a noisy family above me. You cannot make that promise. Housings for older people. Yes, the law does allow federally and in Iowa to have 55 and older communities that are age restricted. Disability, remember, this includes someone with AIDS or someone that is in a rehab opportunity. Addiction recovery would be another way to say that. They are protected. We also need to remember that someone with a disability is allowed to make reasonable accommodations at their expense, and they can be required to return it back to its original condition minus basic wear and tear. 76 at the bottom, no block busting and steering. Block busting is what we do to a seller. Steering is what we do to a buyer. The only reason you should ever deny showing someone a property is you know for a fact they cannot afford it. Redlining at the top of page 77. This is where banks use maps. This is actually a lending law. Banks use maps to determine where they would award government insured loans like FHA and VA to minorities. Know those exemptions. This is for owner occupied 1 to 4 units. So owner occupied 12 units, they are not exempt. I would review advertising. But I would also, I think I had you add to your notes, people have up to 1 year to file a complaint with HUD. Under technology and communication, page 78 at the top, you've got the multiple listing service. Now, I think you know what this is. This is a way that we communicate our listings and data with other agents in our communities, but a seller is not required. You're not required to be a member of it. There's lots of agents that are not members of a local board and they're MLS. That's not what's required. The other big one on here is the internet and email, those 4 items that must be included on your electronic communication. Your full name of brokerage, city and state, and states where you're licensed. And I would know on page 79, the electronic signatures, that's a federal law that allows them. And then the do not call registry. I would know that if you have someone contact you, you've got 3 months that you could follow up with them. 18 months you could follow up with them if they did business with you. Okay, how did we do?